South Mountain lies inland from the Annapolis Valley, a wooded ridge running through Kings County in Nova Scotia. Contemporary descriptions place it beyond the main roads, reached by narrow routes that thin as they climb. For much of the 20th century, it remained physically close to towns like Wolfville and White Rock, yet administratively distant, an area visited infrequently by officials and rarely mentioned in provincial reporting unless prompted by hardship. Public records show the Goler family has been in this area for generations. Census listings and local documentation recorded household members, ages, occupations, and addresses in the same restrained manner applied to any rural family. Names appeared, disappeared, and reappeared across decades, reflecting births, deaths, and relocations within the mountain community. Nothing in those entries marked the family as a subject of criminal concern. What drew limited attention, according to later journalistic accounts, were living conditions. Reporters who visited South Mountain in the mid-1980s described extreme poverty, overcrowded dwellings, inadequate sanitation, and homes in visible disrepair. These descriptions, however, entered the public record only after the case became known. At the time they existed, such conditions were not the subject of formal enforcement action. Crucially, before 1984, there is no record of police charges, court proceedings, or criminal investigations involving the family. No indictments were filed. No trials were scheduled. The family's interaction with the state, as reflected in accessible records, remained administrative rather than judicial. At this stage, the Golers existed as they had for years, documented, counted, and largely unseen. They were present in the record, but not yet before the court. If documented cases and forgotten court records are your interest, you can subscribe to the channel. Each episode focuses on what entered the record and what did not. Before the events of 1984, the Goler family was not entirely unknown to public institutions. Records and later reporting indicate periodic contact with local schools and social services in Kings County, interactions consistent with families living in poverty and geographic isolation. These contacts were administrative in nature, focused on attendance, welfare concerns, and household conditions rather than criminal behavior. According to summaries published after the case emerged, some children from the household attempted to disclose mistreatment in the years preceding 1984. These disclosures were made within institutional settings, most often schools, where concerns were noted, but did not progress beyond internal review. At the time, the information did not result in police involvement or formal charges. In documented instances, children who raised concerns were returned to the household. There is no surviving record from this period indicating that disclosures were substantiated to a legal standard, nor that they triggered removal orders or criminal investigations. The system responded through routine procedures, not emergency intervention. Importantly, no criminal file was opened during this period. Police records do not show charges, arrests, or active investigations connected to the family before 1984. Courts were not involved. What existed instead was a paper trail of institutional contact that stopped short of enforcement. This stage of the record reflects proximity without escalation. Schools and social services came into contact with the family, observed concerns, and documented them within their own frameworks. Those observations did not cross the threshold into prosecution or court oversight. As a result, the case remained fragmented across agencies. Notes were made, children, and were returned. And despite moments of contact, no single report became a criminal file. In January 1984, the pattern of limited institutional contact ended. A 14-year-old girl from the Goler household made a direct disclosure to a school authority in Kings County. Unlike earlier concerns that remained informal or internal, this report was explicit enough to trigger mandatory reporting obligations in effect at the time. School officials documented the disclosure and followed prescribed procedures. The matter was referred beyond the education system, initiating contact with Child Protection Services. What had previously existed as an administrative concern now entered a framework designed to assess risk and safety. Child protection authorities responded by opening a formal file. The disclosure was treated as a potential criminal matter rather than a welfare issue alone. Given the nature of the allegations, police were notified. This step marked the first recorded involvement of law enforcement in the family's affairs. The Royal Canadian Mounted Police began preliminary inquiries, coordinating with child protection workers. Interviews were arranged, and assessments expanded beyond the initial report. What distinguished this disclosure from earlier attempts was not its setting, but its outcome. It moved decisively outside institutional discretion and into statutory process. At this stage, no charges were laid. The disclosure functioned as a catalyst rather than a conclusion. Its significance lay in procedure, not prosecution. Once the report crossed into police jurisdiction, the matter was no longer managed internally by a single institution. From this point forward, the case was governed by investigative standards rather than administrative judgment. The school's role ended with documentation and referral. Oversight shifted to agencies with legal authority to compel interviews, remove children, and examine potential criminal conduct. With that transfer, the case left the school system entirely. It entered law enforcement, where its scope would soon expand beyond a single disclosure. Following the January 1984 disclosure, responsibility for the case shifted fully to law enforcement. The Royal Canadian Mounted Police formally opened an investigation in Kings County, working alongside child protection authorities. What began as a single report was now subject to criminal inquiry. One of the first actions taken was the removal of children from the household. This decision, documented in later reporting, was based on assessed risk rather than any determination of guilt. Children were placed under protective supervision while interviews proceeded. At this stage, the focus remained narrow, centered on the initial disclosure and the immediate household. Investigators conducted interviews with children and adults connected to the family. These interviews followed established procedures and were carried out across multiple locations, including schools and temporary placements. As statements were collected, investigators identified overlaps and patterns that extended beyond the original report. The scope of the inquiry widened as additional allegations emerged during these interviews. What distinguished this phase was accumulation rather than escalation. Each new statement prompted further verification, leading investigators to expand the list of potential victims and alleged offenders. The inquiry moved outward from a single household to a broader family network. Throughout this period, no public statements were issued, and no charges were immediately announced. The investigation unfolded largely outside public view, governed by evidentiary thresholds rather than media attention. The pace reflected the complexity of coordinating multiple interviews involving minors and the need to corroborate accounts before proceeding. By the time this initial investigative phase concluded, the case no longer resembled a single complaint under review. The volume of statements and the number of individuals involved indicated a matter of unusual scale. The investigation had grown beyond its point of origin, setting the stage for formal charges to follow. By mid-1984, the investigative phase moved into its next formal stage. Following months of interviews and evidence review, prosecutors authorized the laying of criminal charges. In total, approximately 170 charges were filed in connection with the investigation. Contemporary reporting identified this as one of the largest charge packages of its kind in the province at that time. The charges were laid against multiple adults, including both men and women, all connected through extended family relationships and shared residences. Each accused was charged individually based on statements and evidence gathered during the investigation. The volume of charges reflected aggregation rather than a single legal theory. They were distributed across numerous counts, rather than concentrated in a small number of indictments. In public summaries and court records, the nature of the charges was described using the language of the criminal code in force at the time. These included sexual offenses involving minors, referenced in non-graphic legal terms. Prosecutors did not present the case as a single narrative event, but as a series of alleged offenses occurring over an extended period. The laying of charges marked the first point at which the case entered the public judicial record. Names of the accused appeared in court documents. Dockets were opened. Proceedings were scheduled across multiple appearances rather than a single trial date. The scale of the case required coordination among prosecutors, defense counsel, and the court system to manage volume and scheduling. Importantly, the filing of charges did not conclude the matter. It defined its parameters. Each charge would now need to be addressed through plea, trial, or withdrawal. The investigation transitioned into prosecution, and evidentiary standards shifted from assessment to proof. With this step, the case moved fully into the court system. What had begun as a single disclosure now existed as a multi-defendant prosecution, unfolding across dozens of counts. The record reflects a case proceeding at a scale rarely seen in the provincial courts. Once charges were laid, the case entered a prolonged judicial phase. Proceedings unfolded across multiple court appearances rather than a single consolidated trial, reflecting the number of accused and the volume of charges involved. Some defendants entered guilty pleas, while others proceeded to trial. Each case was addressed individually, even as they remained linked by investigation and timing. Court reporting from the period emphasizes process over spectacle. The prosecution relied on evidence gathered during the investigation, including recorded statements, corroborating accounts, and supporting documentation. These materials were introduced according to established legal standards. Testimony was presented within the courtroom, but contemporary summaries avoided reproducing or dramatizing its content, focusing instead on outcomes and legal sufficiency. The offenses were framed strictly within the criminal code provisions in force at the time. Charges were articulated using statutory language, and the court evaluated them on the basis of admissibility, credibility, and consistency. Judges ruled on motions, accepted pleas, and scheduled hearings as required. Where trials occurred, verdicts followed deliberation rather than immediate judgment. Throughout the proceedings, the court maintained procedural separation between defendants. There was no single narrative verdict. Each accused faced specific counts, and outcomes varied accordingly. Some charges were resolved through plea agreements. Others required full adjudication. Notably, the public record of the trials is restricted. Reporting focused on dates, pleas, verdicts, and sentencing ranges rather than detailed courtroom exchanges. This restraint reflects both publication standards of the time and the legal protections surrounding cases involving minors. As the proceedings progressed, verdicts accumulated incrementally. Guilty findings were entered across multiple cases, while others concluded through plea without trial. By the end of this phase, the court had rendered decisions on the majority of charges before it. With verdicts reached, the case moved toward sentencing. The judicial process had completed its central task, determining legal responsibility under the law as written. Following the completion of trials and the entry of guilty pleas, the court proceeded to sentencing. By the conclusion of this phase, 15 individuals connected to the case had been convicted of criminal offenses arising from the investigation. Sentencing hearings were conducted individually, with the court considering the specific charges and circumstances attached to each defendant. Court records and contemporary reporting indicate that custodial sentences range from 1 to 7 years. The length of each sentence reflected the number of convictions entered against an individual and the statutory provisions governing the offenses at the time. In at least one instance, a 7-year prison term was imposed, representing the most severe sentence recorded in the case. Sentences were delivered within the framework of existing law. Judges applied the criminal code as written, issuing penalties authorized by statute. No exceptional sentencing mechanisms were employed, and no departures from standard procedure were noted in the public record. Each judgment concluded the court's consideration of that defendant's criminal responsibility. The sentencing phase did not produce a single defining moment. Instead, it closed the case incrementally, as each accused received a disposition. With each sentence entered, the scope of active litigation narrowed. Appeals were not a prominent feature of contemporary reporting, and no subsequent trials reopened the core allegations. Importantly, the record does not preserve judicial commentary beyond formal reasons for the sentence. Public discussion of the case continued, but the court's role was limited to the imposition of lawful penalties. Moral interpretation and broader analysis occurred outside the courtroom, not within it. Once sentencing was complete, the criminal proceedings ended. The courts had fulfilled their mandate. Charges had been tested, verdicts rendered, and penalties imposed. From that point forward, the case ceased to exist as an active prosecution and entered the historical record. With the conclusion of sentencing, the case did not recede from public view. Instead, it entered a second phase, one shaped not by the courts, but by national media and public analysis. In 1986, the case received extensive coverage in Maclean's, bringing details of the investigation and its outcomes to a wider audience across Canada. This coverage did not revisit courtroom proceedings in detail. Instead, it reframed the case within a broader social context. Journalists focused on the conditions under which the family had lived: extreme poverty, geographic isolation, inadequate housing, and long-term marginalization. These factors were presented as documented conditions, not explanations or excuses, and were drawn from on-site reporting and official descriptions. The reporting also examined the role of institutions that had interacted with the family prior to 1984. Schools, social services, and government agencies were discussed in terms of contact rather than culpability. The emphasis remains on chronology, who knew what and when, rather than assigning blame beyond the established legal record. Public reaction followed the publication of these accounts. Commentary appeared in print and broadcast media, often centered on questions of oversight and prevention. These discussions were not part of the judicial process and carried no legal authority. They existed alongside the court record, expanding the case into a subject of national reflection. What emerged during this period was a shift in classification. The Goler case was no longer treated solely as a concluded prosecution. It became a reference point in discussions of poverty, child welfare, and institutional limits, topics addressed through reporting and analysis rather than verdicts. At this stage, the story left the courtroom entirely. It entered print, where it would be preserved, interpreted, and revisited as a matter of record rather than law. Years after the criminal proceedings concluded, the Goler case resurfaced briefly in the public record through policy discussion rather than prosecution. One of the most visible figures in this phase was Donna Goler, who emerged as an advocate drawing attention to gaps she identified in existing child protection and offender restriction frameworks. In 1998, the case was referenced during proceedings in the House of Commons of Canada. During a parliamentary debate, a member of Parliament cited advocacy connected to the Goler case while discussing limitations in the criminal code related to supervision and restrictions placed on convicted offenders. The reference did not reopen the case, nor did it revisit the convictions or sentences already imposed. Instead, it positioned the case as an example within a broader legislative discussion. The debate focused on whether existing legal mechanisms were sufficient to prevent convicted offenders from residing in environments where children were present. The Goler case was mentioned as part of the public context that had prompted renewed examination of these provisions. No single legislative outcome was attributed directly to the case, and no claim was made in the record that it produced a definitive reform. What distinguishes this moment is its formality. Unlike media analysis or academic study, the reference entered the official parliamentary record. It marked one of the few instances in which the case appeared in federal proceedings after the courts had concluded their work. The discussion was brief and procedural. Once the debate moved on, the case did not remain a standing issue before Parliament. Its presence served as a point of reference rather than a catalyst. In this way, the Goler case reached Parliament only in passing, acknowledged, recorded, and then left behind once more. After the conclusion of sentencing and the brief return of the case in parliamentary discussion, the Goler case passed fully into the archive. No further criminal charges were filed. No new prosecutions emerged. The court record closed, and the legal system did not revisit the matter. What remains instead is documentation. Court files preserve the charges, pleas, verdicts, and sentences. Contemporary journalism, particularly national reporting from the mid-1980s, records how the case was presented to the public at the time. Together, these sources establish a fixed account of what was investigated, prosecuted, and resolved under law. The case also survives through scholarship. In 1998, David Cruz and Alison Griffiths published On South Mountain, a work that examined the case through interviews, public records, and historical context. The book did not alter the legal outcomes. It did not reopen proceedings. Its role was descriptive rather than corrective, adding a research narrative to an already closed file. Beyond these materials, the record grows quiet. There are no subsequent judgments, no appeals that reshape the outcome, and no official findings that revise the conclusions reached in court. Later references, when they appear, draw from the same limited set of sources: trial coverage, government transcripts, and published analysis. In this way, the case persists without evolving. It exists as a completed prosecution, followed by public examination and then archival rest. Its details do not circulate through oral tradition or unresolved speculation. They remain fixed in print, transcripts, and bound volumes. This is where the story ends, not with resolution beyond the law and not with disappearance. The Goler case does not conclude in memory or interpretation. It concludes where all closed cases do, in the record.